All right, so we were here for restitution.
I believe the state was going to try to provide real receipts. This is the one where the complainant was claiming something like 5 million.
1.6 million. And judge has spoken with the, excuse me, I've spoken with the complaining witness. He has not been able to produce those receipts or estimates. I've spoken to him about the likelihood of any kind of recovery. So because of that, judge will waive restitution or are able to proceed.
So y'all are waiving restitution.
We are, judge.
And we have no objection to that, Judge. I believe basically what happened, my client showed up, got himself in a mess, was riding his bicycle downtown just a short while later when the police arrested him. There were no medals on him. It wasn't like he took any of that stuff, but he just wanted to get this over with, and move on.
But then we have the robbery and then the theft.
Yes, judge. And I've spoken with the complaining witness about any hopes of recovery, and he understands that the odds of restitution are.
Well, I mean, and this is just me just asking. So do people, and I'm not talking about you specifically, so do people get charged with an offense and then it's like, well, this person can't afford to pay the restitution, so that's a wash? Is that what we're doing now?
We have not been able to find any kind of receipts or estimates to back up any kind of claims for us.
Okay. Do I have the complainant zoom in and say that he didn't provide you all with restitution amounts, and I'll go forward?
We'll see if we can get them on, judge.
All right. Thank you. Thank you. How do you pronounce your first name?
Liana.
Liana.
This is like an L is not.
Now, the double L's always throw me.
My dad called me Liana, so.
Okay. All right. The court is calling 2024 CR 4899, State versus Liana. Ganal, could I have parties announced for the record?
Lauren Espinoza for the state, Bridget Gossett for defense.
And are you Miss Ganal? All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Liana Ganal who was placed on deferred adjudication in 2024 CR 4899 for the offense of burglary of a habitation on August 27, 2024 for a period of 4 years? Is that you?
Yes.
All right. State.
Violated condition number 1, on or about the 21st day of June 2026 in Bexar County, Texas, the defendant Liana Jen Arrigo Ganal committed the offense of theft in violation of condition number 1.
And I'm so sorry, just a moment. In reviewing the admonishments, I don't have a copy. In reviewing the judgment, the offense should be attempted burglary of a habitation. So would you like to make an amendment to the motion to enter adjudication of guilt?
Yes, Judge, state would move to amend the offense to attempted burglary of a habitation.
Any objections?
Objection.
All right, sorry, State, you may proceed.
Violated condition number 1, on or about the 21st day of June 2026 in Bexar County, Texas, the defendant Liana Jen Arrigo Ganal committed the offense of theft in violation of condition number 1.
How do you plead to that, true or not true?
True.
State will waive the remaining.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find you true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion, continue, alter, and amend for Sabbath and run concurrent with cause 2026 CC 011069, which is the theft.
That's our agreement.
All right, you said 011069?
Correct.
And this is the only outstanding case?
No, Judge, once that plea takes place, we will TIC the drug case, but I have the dismissal for the court today.
Okay. And then after that's taken, because they won't transfer her without everything being closed.
Correct. So it'll just be the plea on the theft and then we'll close it for now.
All right. You want to raise your right hand for me, please? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Liana Jen, Urigo.
Okay. So what is your drug of choice? And how long have you been using? When did it start?
It's been on and off since 2015. Since around 2015.
And do you have a family support system?
Yes, I do.
And who is that?
My parents and my son.
Okay.
My parents mostly.
Okay. And how old is your son?
He's 13.
Okay.
Judge, when she first pled, I represented her originally, and her parents were very, very active in her support.
Mhm.
And they were present in court the times that she had to appear.
All right. I'm going to give you some choices today, right? All of the choices that I'm going to give you, you're going to be in custody. It's just going to depend on you what you're in custody for. Like, are you in custody to be transferred to prison? Or are you in custody to go to inpatient treatment? Okay. You know yourself better than I do, probably better than your attorney and the state and your probation officer does. So you know whether you can complete this successfully or not. One, I can revoke you and I'll sentence you to 3 years in prison. You get credit for any time that you've been in custody. I'll request the therapeutic community. Just because I'm requesting a therapeutic community for you doesn't mean that they will give it to you. Your other option is I will deny the motion, alter the main conditions. I'll ask that you remain in custody, do a referral to felony drug court, and a referral to SATF. Those are your options.
Just for clarification, I believe it's a state jail felony.
No,
Is
it's
it?
an attempted.
Oh, okay, I'm
Yeah,
sorry.
so it's third, yes.
I'm sorry,
Yes.
I'm looking at the new case.
Oh, no
I'm
problem.
sorry.
Yes.
That you want to make aware that she was evaluated on felony drug court or at that time, not be criteria.
Okay. All right. And was that because of lack of drug use?
Criteria. You did. And at that time, also felony drug court was at the top.
All right.
Double.
So we can refer back, right? So those are your choices. Which do you prefer?
They're gonna be holding me just for a few months before telling me this.
Well, what I can tell you is felony drug court. It's Monday. They'll probably evaluate you before the week is out, and you'll know before the week is out whether or not they're accepting you in the program. SATF, I don't know what the wait time is for SATF.
I think she's a little confused. I explained to her the recommendation of the ADA.
Mhm.
The drug court, that's completely different than SATF. That's what the judge is telling me.
Yeah.
So how many years would I be held total for?
Well, drug court is not a holding
Okay.
in total necessarily. It's a treatment court that's designed to focus on what your issue is, right? So felony drug court, if you're accepted in that program, they may say, you know what? SATF is the best place for her, and they'll have you placed in SATF, but you will not be supervised by this court. You'll be supervised by the felony drug court. Felony drug court is approximately a 2-year program. And if you complete everything, you'll probably be terminated in a good way, not terminated in a bad way.
You're not gonna be any custody.
No. Thank you.
I think that's why she's confused.
Okay.
The felony jail court, they can, if they screen you, they can say, you know what, she can be released, but we need to see her on a weekly basis, on a bi-weekly basis, and then they'll recommend other treatment. But you first have to be evaluated and you have to be accepted to the jail, to the felony court.
Okay, and if I don't get accepted, they're gonna send me.
You're going to be going to SATF.
Okay. Okay, so my choices are whether to go to TDC for 3 years or to go to felony drug.
Or SATF. If felony drug court doesn't accept you, then it will be SATF.
Okay, that's my choice.
Yes. So which do you prefer?
Yes, I don't want to be in prison for 3 years.
Okay. All right. The court will then, and are you waiving your right to appeal?
Yes.
Okay. The court will deny the motion, alter and amend conditions. In custody, there should be a referral to felony drug court. If not accepted, then SATA. If for some reason the jail accidentally releases you and you know they're not supposed to, because you're supposed to remain in custody, either to be accepted to felony drug court or SATA, if they release you by accident, the next business day, you need to come in court and say, Judge, they released me by accident. Here I am. You understand?
My accident will be like the next couple of days, but if they do that, then
Yes. Okay.
Okay.
All right. Do you have any questions?
How, so they're gonna be holding, that I will be held in custody until they do the assessment?
Yes. So this is what I want you to focus on. Felony drug court, they will come see you
Okay.
before this week is out. They will make a decision probably before this week is out on whether or not they're accepting you in their program.
Okay.
If they accept you in the program, you don't have to worry about waiting for a bed for SATA necessarily, because you being accepted in felony drug court. If felony drug court does not accept you in your program, then you're going to be waiting at the jail till you're transferred to SATA.
And then that's gonna be for like 3 to 4 months.
SATA is, depending on how you do, you're looking at 90 to maybe 180 days. All right. And this is what we'll do, counsel. Norma, can you give me a phantom date on this?
For how many days?
Let's do 3 weeks.
I can do August 31st.
All right. So we're going to call you on August 31st. Now, if felony drug court has already accepted you, we're going to take that off the docket. If they have not accepted you, then that's for me to make sure that you're on the wait list or the transfer for SATA. I don't want to lose you in the system. Now, if you go to the jail and you say, hey, I have a court date on August 31st, you know what they're going to tell you? They're going to tell you you don't have that court date, because I have to put a phantom date in the system. Otherwise, it will stop your progress in the system, because they'll say, oh, can't do anything with her because she has a court date. All right. But know that I know, your attorney knows, and we know that you have a court date here on August 31st. No, I mean, you can tell people, but let me just tell you, it's not going to show up in the system.
Okay.
They're going to tell you you don't have a court date on that date,
Okay.
but we know you do.
So on the morning of August 31st is the first time that we mentioned that's when they're.
I'm sorry, what?
So the morning of August 31st is the first time they're gonna mention that.
No. August 31st is just a date for me to make sure that everything is going well for you.
Okay.
Think of it as that way.
Okay.
I'm trying to make sure that August 31st, evaluations have already been completed and you're on your way to the next stop. Okay.
Okay.
Any other questions?
No.
All right. Thank you. And discovering there's some mental health issues, concerns. I understand.
State's ready, Judge.
I mean, legally, I have to give him a competency evaluation. I just don't understand why people are waiting till the last minute. Norma, see if they can put him down for an emergency competency with the magistrate judge. Just have a seat.
Yes, sir.
Thank you.
My client has spoken to me, and I believe he mentioned it the last time he was here when I was stuck in trial somewhere else. He'd like to withdraw his plea.
Mhm.
I've explained to him that all we can do is ask the court to give him back his plea.
Why does he want to withdraw his plea?
Well, my understanding is when he took the plea, Judge, he was hoping to get the probation and get out of jail.
Mhm.
And he understood that there was this onus of possible restitution, but he wanted to get that done. And since he's been sitting in jail for at least, 3 weeks, a month?
Mhm. Well, you all can file a motion. The court will hear it.
Okay.
And then make sure the complainant is here for sentencing if the court rules against his motion to withdraw. So how much time are you all asking for?
Today's Monday. You want to come back on Friday?
No, not Friday. Norma, put this for the, let me see. Norma, you can put this for the 19th.
Yes, sir.
And tell the complainant he'll need to be here in person.
I will, Judge.
All right. We'll see you all on the 19th. All right. The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's $1,000 fine. All right, just one moment. All right, to the person who's on Zoom, your case has been dismissed. Your attorney should probably have that information for you. Thank you. All right, and the state recommends community supervision. Did you understand that to be your plea? State defense, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
There you are.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours community service restitution, DWI intervention, VIP live, ignition interlock full term, Texas license suspension for 2 years, and 10 days in the Bexar County Jail as a condition. Did you understand that those are recommendations from the state, and other than what's statutory, the court does not have to follow those recommendations? Did you understand? All right. State, with regards to the 10 days Bexar County Jail, are you objecting if the court were to place her on GPS?
No, Judge.
All right, then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge Garth, State Exhibit 1, including all attachments. No objection.
All right, state, you may be excused.
Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Ms. Fields understands the seriousness of this. She has actually completed the DWI intervention course in advance. She is the sole, really primary caregiver. She of 3 school-age children. So we would appreciate if you would consider the GPS for those 10 days, Judge.
All right. And does she have ignition interlock?
She does not, because she does not have the vehicle. She has the multiplies.
And are you employed or no?
It's a children.
Okay. Oh, no problem. So what's going on with you? Because this is your 3rd DWI. So that means that you're one of those people who cannot drink and know when to stop. And with regards to this accident, the hitting of the mirror, has that been paid for? So why are you drinking?
I wrote it. The letter that wrote everything out.
You can just tell it, I mean, basically, Judge. Just let her know about the vehicle.
Okay. So do you need, this is the thing, and the reason why I ask these questions is because people are placed on probation. I want them to be successful. And if there are some issues that are going on with you that are impacting your decision making, I need to know so I can set specific conditions so that we won't be here again.
Yes, in the past years, I made much mistakes.
Do you have family support? All right, who's your support system?
System, whether fathers passed, for the sisters and therapists, my colleagues, and street, I grew up on a preacher's child, in church, and have support all around me. I just make choices due to relationship.
Okay. Well, this is what I can tell you. And this is what I would always tell my clients. Everybody is on a journey in this thing we call life. And where you are now, hopefully, there will be an improvement and it won't be where you'll end up. So with regards to this GPS, so is it for employment? What is it for?
You mean the,
I mean,
10 days in jail?
Yes.
Judge.
No, I mean, what does she need?
Oh, I see.
Because I can place her on partial or either full house arrest.
I know you're not part of it, but you leave the house and take care of these expectations.
No, it's not spotting.
So during those 10 days, when you need to leave the house, you're sort of full time.
Yes, it starts on the 19th.
So
Right, so you're not allowed to drive. You cannot, and you're not allowed to drive any vehicles that do not have ignition interlock on it. If you drive a vehicle that doesn't have ignition interlock on it, you know what's going to end up happening? Probation is going to find out about it. A motion to revoke is going to be filed, and you're looking at potentially 3 years in prison. So, all right. The court is going to find her guilty, sentence her to the following: 3 years in prison, suspended and probated for 3 years, regular reporting by Zoom or in person, regular UAs, tests for alcohol, proof of employment, or are you employed or no?
no, Judge, she takes care of her kids full time.
Okay.
Trying to do substitute teaching on my kids.
All right. I'm going to want field visits 1 time per month for 4 months. 100 hours of community service restitution. Deduct 1 hour for every sober support meeting that's completed. I'm going to require 1 sober support meeting per week. DWI intervention, VIP live, Ignition interlock full term, or PAM, if upon providing affidavit of non-driving. Texas license suspension for 2 years. Partial GPS. For 26 days, waive fees. And she's allowed to attend children's activities. I'll just call it children's activities. That includes taking them to school. And DWI education course. Probation, is there anything else? All right. Oh, I'm sorry. So I'm not going to order employment. She says she's a stay-at-home mom. TAP evaluation out of custody, follow TAP recommendations. And do a referral to felony drug court so she can see. And just have her evaluated for trauma-informed care. Is there anything else, probation? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea, because I followed your plea, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? Here's what you have to realize. Anybody could have been killed that day. Could have been children, right? That's the problem in San Antonio. People drink a lot. And then once you drink, you don't realize you've lost your physical and mental faculties, and you just think you're just fine. Again, I tell this to everybody. I have yet to have, in my past, had a client come to me and say, Stephanie, I want to let you know something. I purposely went out to drink to intoxication, and it was my intent to hit somebody, to kill somebody. Nobody ever says that, but you know what ends up happening? It ends up happening, and then the next thing you know, they're crying to you because they killed or injured somebody, and you know, that ship has sailed. All right, once you go over conditions with me, so we're going to recall you for September 24th. At that time, the state is going to tender an offer to your attorney. Then your next court date, if you all have not reached an agreement on that date, I'm going to give you a plea deadline date. And then after that, it will be jury trial. Do you understand? Yes or no?
Two.
Yes.
All right. Do you have any questions?
Two.
Yes.
All right. If your question is about the facts of your case, then don't ask that question. That question should be for your attorney. But if it's about the procedure of the court, then you can ask it. So any questions?
No.
No.
All right. Thank you.
Perfect.